Hello, everybody. Welcome back to the channel on this fine Friday night, 7:30. I'm doing yet another late night live because this is a pretty important situation going on. So I wanted to take the time to really dive into the case today, read it myself outside of whatever is being said in the tabloid media, in the institutional media. As a lawyer, just apply my own lens here. So this live is going to be like a little bit different than other lives, and I have a couple things to go over first. But I just want to let me see. Okay, I just want to tell y'all, like, I'm very nervous to be covering this case, like, because I've seen a little bit online of how some people are taking it. I want to be respectful to the fact that people have different opinions for different reasons on this case. And as you can tell by the title, I am not planning on infusing my opinion into the analysis or the discussion of the case to the extent that I'm able to not infuse my opinion, right? I do just want to say out front, and this is the last time I'm going to address it, what my opinion and belief is from a moral perspective. And then I'm going to set that aside and we're going to go through the case from as much of a non-biased perspective as I am able to. Okay. I know that a lot of y'all have a lot of opinions. I would ask that unless you've read the case, right, that you kind of keep an open mind about this, because if you start something with an open mind from any direction or any side, it's better for your understanding of this case and how we can apply it in the future, how it was applied in the past, etc. It's just a better way to learn. Okay. My personal belief, my personal ethical moral belief on this case, on this issue, is that individuals should have the right to their own choices on whether or not to take a pregnancy to full term. That being said, this is not a video about my opinion. So I would respectfully ask that y'all refrain from imposing what you think I think and what you think I'm saying on me, because this is not about me or my opinion. This is about me explaining to y'all how to read a Supreme Court case, what led up to this particular decision, and how you can further use this knowledge to understand more different Supreme Court cases and follow along with this particular development of constitutional rights issues as well. Okay. That being said, now I'm going to share with y'all a little bit of a PowerPoint, because there's some stuff we have to learn before we get into this case. Okay, so here we go. I am sorry I cannot do a full screen. I've been rushing around to set this live up, so this is as good as it's going to get. Okay, so I have a couple rules that I want to do. Ground rules for this discussion, and they were sent to me by my lovely mod, Simply Monica, who's going to be in charge of moderating the chat along with a great group of other moderators, and we're going to keep it respectful and civil in the chat. There is a lot of places, let me just tell y'all, there's a lot of places on the internet right now where you can take your foolishness and go fight and go argue and go do all that foolishness. There's a lot of places you can do that. You're not allowed to do it here, okay? You will be respectful of other people. You can have your opinion, but you will be respectful. This is going to be the rules, okay? Please do not contact anybody mentioned in this video. Number 2, do not wish ill or physical harm to anybody in this video. Number 3, Monica, you're so funny. If you are against any of our rights, this isn't the channel for you. I agree. Number 4, disagreements are fine as long as they remain respectful. So you cannot call names, and no belittling people. No lewd or suggestive comments. Please do not spam. It is distracting. Please understand super chats will be read as soon as I can. Be respectful. Do not come into the stream to delegate or disrespect. This is funny. Do not come in to disrespect or delegate to the lady on the screen, as she is doing this shit for free and for the greater good. And if you would like to help Bam Margera, you can contact Monica by her Instagram, which is the same as her name here, or by bjmodcontact@gmail.com. Okay. So those are the ground rules. Y'all better follow them, and they're going to be very strictly enforced on this chat today. Okay. So, as y'all know, today, the Supreme Court issued a ruling on a case that we're going to call Dodds. Okay, Dodds. Dodds versus was like Jackson Women's Health or something like that. We're going to get into that case. But before we get into it, there's some stuff y'all need to know that led up to this case. Now, if you're wondering what authority I have to talk about this issue, I don't really, but I've been to law school. I've taken constitutional law. I've passed the bar exam. And I also took a class with Professor Dorothy Roberts called Reproductive Rights and Justice, where we went over all these cases. So I have learned quite a bit about them over the last 5 years. So let's get to some of those cases. Two big cases y'all are going to need to know for this particular court case are going to be Roe versus Wade, which is a case you probably have heard of. And the second case, which is based on Roe versus Wade, is called Planned Parenthood versus Casey, or Casey for short. Now, Roe versus Wade was decided in 1972, and it granted, I'm going to be using the language that they use in the statute, but people could disagree about the language used here, but I'm going to be very specific to use the language they actually use in the cases and in the statutes, right? So Roe versus Wade specifically, for the first time in American constitutional jurisprudence, granted and affirmed or gave or extended the right to have an abortion to women in 1972. Roe versus Wade was decided on grounds of privacy, and they used a few constitutional amendments to make their case. The First Amendment, 4th, 5th, 9th, and 14th. Okay, so just keep that in your mind because we will be talking about it later. But then Planned Parenthood versus Casey came along in 1992. And in 1992, the Supreme Court, much like the decision today, had the opportunity to re-examine Roe versus Wade and to decide, is this really the right decision that we made? So they re-examined Roe versus Wade in 1992 in that Casey case. And what the Supreme Court did in Casey is they modified Roe versus Wade. So Roe versus Wade had this trimester framework where it was like, yeah, you have the right to an abortion in the first two trimesters. Like, if you don't know this, there's 3 trimesters traditionally for a pregnancy. And they say in Roe versus Wade, they say, okay, in those first 2 trimesters, because a woman has a right to privacy, she can have an abortion. And in the first two trimesters. Now we're going to talk about the specific lens that the Supreme Court applied here, which is called a constitutional standard for review. But I just want y'all to get it in your head, these 2 cases, right? So that was Roe versus Wade. Casey asks basically the same questions as Roe versus Wade, comes out with a little bit of a different answer, but the ultimate answer was yes. Women still do have a constitutional right to abortion under this fundamental liberty type of, hold on, let me show y'all this. Under this fundamental liberty type of argument under the 14th Amendment. So it kind of chipped away at Roe a little bit. And people were concerned about that because they were afraid of a day that may come like today where Roe versus Wade just gets completely overturned. Okay, so Casey replaced the trimester framework with a different test called the undue burden test. And it only, like I said, upholds the liberty portion that cites the 14th Amendment. Now, we will have an opportunity to talk more about Roe and Casey as we progress through the case. But there are a couple other cases that you should know that are kind of related to Roe versus Wade, but have a little few differences as well. So this is supposed to say 1965. So in 1965, the Supreme Court heard a case called Griswold versus Connecticut. And in Griswold versus Connecticut, the Supreme Court determined that you have a constitutional right to birth control. You have a constitutional right to contraceptives, is what they called it in that case. But look, we're all the way back in 1965, and we do have the Supreme Court for the first time affirming the rights to contraceptives. And this was also decided on privacy grounds. Okay, your right to privacy. We'll get into more of the framework later, but just keep this in mind. Then 2003, which was many years after Roe versus Wade, Lawrence versus the state of Texas was an anti-sodomy law that basically in the state of Texas, they wrote this law that made it illegal to have same-sex intimate relations, right? And what the government what the Supreme Court said was that's unconstitutional. So someone sued someone and it went all the way up to the Supreme Court, and the Supreme Court said same-sex relationships and intimate relations between same-sex partners are protected by privacy rights. So we see this concept of privacy rights coming up yet again. So in that case, a Texas statute, right, a piece of legislation which criminalized same-sex intimate relations was ruled to be unconstitutional by the Supreme Court. And in part, Lawrence versus Texas did rely on Roe versus Wade privacy and I believe the Casey, right, Roe versus Wade and its progeny for the dependence on this Lawrence case. Now, I'd have to look back into that more specifically, but that's what I'm remembering at the moment. Don't quote me on that particular part. Okay. And then a case we probably are the most familiar with is the 2014-2015 case Obergefell versus Hodges, which protected same-sex marriage, right? So we have Lawrence versus Texas, which protects like sodomy, right? Like the right to, intimate relations. And then in 2015, several years later, that intimate relations protection was extended to same-sex marriage, right? And the reasoning in the Obergefell case was based on the fact that marriage is a fundamental right. That's going to become important because one of the reasons or grounds that the Supreme Court based its decision today on was that abortion is not a fundamental right like marriage would be, okay? That's just something to keep in mind as you want to understand how we got to this point. Okay, another concept we need to know before we start reading is the notion of constitutional standards of review. So what a standard of review actually is, I have a note down here with the definition, is these standards are kind of like filters or formulas. The way I like to think of it is like, which color glasses are the judges going to put on whenever they're analyzing this case and making their decision. You can also maybe think of it as if a constitutional standard of review is kind of like an algebra formula. You know how you have the same, quadratic equation each time, and then you're going to plug your numbers in based on the specifics of that math problem. That's kind of what a constitutional standard of review is. Depending on different aspects of the case, it's going to require the judges to apply a different filter, a different standard, a different set of, a different color lens, right? And we're going to get into exactly what that means. But what a standard of review is what standard the Supreme Court is going to use in evaluating whether a law or a government decision or whatever, but we're talking about a law today, whether a law is constitutional. Okay. So a constitutional standard of review is the filter or the lens that the Supreme Court judges have to use to evaluate whether a law is constitutional. Okay. There are 3 constitutional standards for review. One is called rational basis, and that's like the basic standard of review. And then you have 2 other standards, and they get higher. We're going to go into the definitions. If this doesn't make sense, don't worry. We're going to get into it. But rational basis is number 1. It's like the basic one. It's like the thing. It's like, is this constitutional? Yes, no, we'll see. But there are certain specific cases where there's something called heightened scrutiny, where certain types of variables in this case are going to result in the Supreme Court having to look at that law with a little bit more strictness, right? They're going to have to be a little bit more particular on whether or not that law is constitutional. We're going to get into the reasons why, but I just want to set up the framework, okay? The 2 levels of heightened scrutiny go up a scale, like as you see number 2 and number 3. The second one is called intermediate scrutiny, and the final is called strict scrutiny. Okay, so there's 3 different screens or filters that the Supreme Court can apply when they're answering the question, is a law constitutional? Okay, and based on who the law applies to and what the law says and which rights they might implicate, there's different levels of scrutiny, and you'll come to understand why that is in a moment. So just quickly, the rational basis standard asks the question, is this law reasonably related to a legitimate state interest? Right? The second level of scrutiny is called intermediate scrutiny. And this one will come in, this screen or this filter comes in for the Supreme Court whenever they are trying to decide on cases involving what they call a quasi-suspect class. Now, a quasi-suspect class has basically come to be defined as anything relating to gender or sex. That sex is the word that's most often used, but you're seeing more and more gender be used. And cases relating to legitimacy. That's the legal word that they use for whether or not you were born out of wedlock, in wedlock, who's your mom, who's your dad. Cases, we can get into that when we get into the constitutional law lecture series that I'm going to start. But just know that unless it's involving basically somebody's, unless this law is discriminating based on sex or someone's, and sex meaning like the characteristic of sex, not the act, right? The noun, sex, right? Noun. Yeah, not the verb. Okay. So unless you're dealing with a gender-based discrimination law, like a law that only applies to women or something like only applies to men, or something to do with like your parentage, then you're probably not going to be dealing in this intermediate scrutiny category. And in fact, this is not the filter that the Supreme Court used for the Dodds case, which we're talking about today. But the definition of this one is where there's a quasi-suspect class like sex or illegitimacy, the question the Supreme Court must ask, the filter they must put on is this substantially related to an important state interest? So you remember rational basis, which is right above it, reasonably related to a legitimate state interest. That gives the state a lot more leeway, right? But substantially related to an important state interest, it makes the state have to do a little bit more proving, right, on their law to make sure that they get to keep it in place and the Supreme Court doesn't overturn it. Okay. And then the final category is called strict scrutiny. Now, there's a whole definitions about strict scrutiny, but suffice it to say, for our purposes, strict scrutiny definitely has been considered to be applying to race. So if it's a law that applies to people based on race, the Supreme Court is going to take out the biggest magnifying glass that they have, and they're going to say, wait. We've seen a lot of discrimination based on race in our day. And if you're going to be making a law based on race, we definitely need to make sure that it is narrowly tailored as much as possible to a compelling state interest. If you're dealing with what's called a suspect class. So you see here we have this quasi-suspect classification, that's gender and illegitimacy, the parentage. Now this narrowly tailored, now this suspect classification, here, I'll write this here, suspect. The suspect classification has more to do with race. Okay, so this is y'all are probably asking why does sex and gender and race and all this stuff have anything to do with anything? Why doesn't the law just apply equally? And that is a question that is a great question and one we can get into in the constitutional law lecture series. But for the purposes of today, just know there's different filters or lenses. There's different tests. There's different formulas that the Supreme Court has to apply when they are determining certain constitutional law cases, based on the things that are mentioned in the law that they're trying to decide whether it's constitutional or not. Okay. So this is just more fleshed out here. The rational basis, remember, is reasonably related to a legitimate state interest. This is the sort of everyone else category when it's not like a suspect or a quasi-suspect class that's addressed in the law. It's just, what are we normally going to look for if it's just a law that applies to everyone and it's just an equal law that applies to everyone? Today's Dodds case utilized this standard of scrutiny. Okay. So this is what the Supreme Court asked about Mississippi's Gestational Age Act, which is what was up for discussion in this case. Reasonably related to a legitimate state interest. Okay. Intermediate scrutiny is that quasi-suspect class. And they ask, is it substantially related to an important government interest? And again, this doesn't apply here. We're here. We're on the rational basis test, according to the Supreme Court. And we're going to discuss these tests. That's why I had to tell y'all what these mean up front. Strict scrutiny asks, is it narrowly tailored? But again, we don't have to ask about strict scrutiny, and the Supreme Court is going to tell us in their opinion why. So 2 more concepts before we actually dive in and read the decision. It's a concept called stare decisis, or you can also call it legal precedent. Stare decisis is a Latin phrase for to stand by things or to stand by the thing. Just so y'all are aware, laws in the United States are made in several different ways. One of the ways that laws are made in the United States is, of course, Congress or the state legislature writing the laws and passing it in the way that you pass a bill through to become a law, right? Another way that laws are made in the United States is through this concept of stare decisis or precedent. And that's whenever the Supreme Court, for example, has decided something back in the day, we're usually not going to keep rehashing that out over and over. Usually, if the Supreme Court decided something, even if it was 100 years ago, and the legal reasoning is still standing, then we're not going to go and overturn that. And so there's this notion that judges and courts have to respect the decisions that other judges have made before them if they're at the equal level of courts, right? The Supreme Court can overturn a lower court, like an appeals court or a state court or whatever, at any moment. An appeals court is usually what they're going to be overturning. But whenever it's like the Supreme Court itself 50 years ago decided something, usually we're not going to like keep rehashing that out. So that's actually a very interesting point about this case, is that it's a little bit unusual for an issue to be decided 50 years ago and then come back around over and over again, like in Planned Parenthood versus Casey, and now again in the Dodds versus Jackson Women's Health case. It's kind of unusual for the Supreme Court to pick up a case and reconsider it and change, or even more rare, overturn their own decision. And that is largely because of this concept and this principle right here, stare decisis. So laws are made in several ways. And one of the ways they're made is that once the Supreme Court decides something, it's the law, even if Congress never wrote it down. So like in Obergefell, for example, this case here, the Supreme Court decided in 2015, there is a constitutional right or a fundamental right for same-sex couples to become married. But here, where are we? But here, not but here, I don't know what I said but as y'all can see here, the concept of stare decisis is like a way that the Supreme Court can make laws. And once the Supreme Court says something, there really is no way to go above them. Like, that's kind of it. I shouldn't say no way. That's not true. And I don't want y'all to think, like, I know some of y'all are very overwhelmed and bummed out about this decision. But the thing about it is there are ways around it if you find yourself on that side of things. There's constitutional amendments. There's state constitutional amendments. And we can get into all the different ways that this could be changed and addressed in the end. But just suffice it to say, for the purposes our purposes right now, stare decisis and precedent is something that here's the definition. It's the doctrine that courts will adhere to the precedent in making their decisions. And the precedent is like what that court decided earlier already, right? It also has its own framework for applications, and we will discuss this later on. So the final point I want to just run over with y'all is, how does the Supreme Court actually make decisions anyway? So it's usually basically just majority rules. There's 9 justices currently on the Supreme Court. Today's decision was a 6-3 decision. For the purposes of how they make these decisions, just think, generally the least common denominator is the law and majority rules. So there's a few different definitions, as y'all can see here. The first one is simple majority. Like today's decision, there were 6 justices that agreed with enough points that it overturned Roe versus Wade. There really wasn't any need to decide which parts of it were agreed or disagreed. It was a simple majority, 6 versus 3. Now, there's another type of decision outcome called a plurality. And that's where you might have 4 justices agreeing on one side, 4 agreeing on the other side, and 1 kind of tiebreaker judge that gets to decide which issues he or she agrees with or disagrees with. And whatever that person decides they agree with or disagree with, let's say they go with the first 4. Now there's 5 people who agree with at least some things, right? So in cases where there's a bunch of issues up for discussion, like let's say there's like 4 issues up for discussion on the Supreme Court. Let's say, half of them agree that these are, constitutional, half of them agree that these are not, and there's like a split. As long as some majority of those justices, so that would be, 5, as long as 5 justices agree on any part of it, the part they all agree on, that least common denominator is the plurality opinion. And whatever that is, it's still majority rules. Now, sometimes there's ties and stuff. I don't really know how that works out, but just for our purposes, just know that that's what plurality means. A concurrence is where a judge kind of agrees with the main part of the majority opinion, but he has a couple, or she has a couple little different opinions they want to throw in, and they'll write their own thing. And then lastly, there's this notion of dissent. And that's people that say, I don't agree with the majority at all. And the dissent, and And the dissent in this case came from this person here. That's Justice Sotomayor. This person here, who is Justice Kagan, and this justice here, Justice Brennan. So this lady, and this man all disagreed with today's decision. They were the 3 on the side that were not in the majority. They were in the minority, and they wrote dissents. Brett Kavanaugh, Justice Alito here, this guy right here is the one who authored the opinion of today. Clarence Thomas, y'all probably have heard of in the news for his very conservative and some would argue the most extreme opinion on the Supreme Court. And he wrote his own concurring opinion, but he did side with the majority. He just thought they should take it an extra step further and start reconsidering all kinds of laws and stuff like that, or all kinds of rights. And then we have, that's Roberts. And then we have this lady who is the second newest inductee to the Supreme Court. I think they just inducted another lady, Dr. Jackson, I believe her name is, but she was not involved in today's decision. Okay. So now I'm going to pull up the actual Supreme Court opinion. Okay. So I have some notes here. I'm going to be looking at them. Y'all behave yourselves in the comment section. Okay. So basically, I'll start here. So basically what we're looking at is a decision that was, the authors already just told y'all who they were. I will show you this. So who we have suing who? Dobbs, State Health Officer of the Mississippi Department of Health, versus Jackson Women's Health Organization. So for the purposes of this live, if you're going to be following along with the notes that I post later on, I'm going to be describing the Jackson Women's Health Organization as the plaintiff and the Dobbs as the defendant, because that's how the lawsuit originated. But in this particular case, that would be a little confusing. That's why I'm telling y'all that. Okay. So we have this statute. Okay. This is now we're finally in here. We're finally doing it. We have this statute, Mississippi's Gestational Age Act. Okay. And that is what is at issue today. The Mississippi Gestational Age Act. So just so y'all are aware, let me read my notes here. The Mississippi Gestational Age Act says a bunch of things. I was going to go over the whole act with y'all, but it's not really important for these purposes. Specifically, this was what they, computer's freezing. Specifically, my word. What they are concerned with is this provision right here. And that provision says, except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being. Now, this is going to be an important turn of phrase as we go through the case. Should not knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. So that's a fancy way for saying abortions after the gestational age of the fetus is 15 weeks is a crime. So Mississippi made it a crime to have an abortion after 15 weeks of pregnancy, which, if you followed along with our Roe versus Wade discussion, you would know that that would, technically speaking, be an unconstitutional law, because the government is not allowed to infringe based on Casey, right? They had that trimester framework, but then the undue burden, like, it's been decided that it's unconstitutional, right? Under Roe versus Wade and under Casey to do this kind of thing, for Mississippi to write this law. So if a lawyer before today's decision would have said, no, that law is unconstitutional, they, technically speaking, would have been correct. But the Supreme Court has now overturned Roe versus Wade, which we will get into. But just for the purposes of the setup of this case, the statute passed in Mississippi, okay? They basically said no abortions in Mississippi after 15 weeks. It becomes a crime. And then the plaintiff, which is this Jackson Women's Health Organization, which is an abortion clinic, and also a doctor from this clinic, also, along with the abortion clinic, sued the state of Mississippi. So Mississippi passes this Gestational Age Act. People say, wait, hold on a second. That's unconstitutional. And then this clinic right here, the plaintiffs, they sue Mississippi. They sue the state of Mississippi for passing what they refer to as an unconstitutional law. Okay. So then what happens next? The state of Mississippi, Dodds, they did not like that decision. They said, no, we're going to appeal it. So they appealed it to a higher court, and that would have been appealed to the federal district court in Mississippi. Now, the federal district court agreed with Jackson, agreed with the abortion clinic, and the federal district court said, no, it is plain as day that this is unconstitutional under Roe versus Wade and Casey. And there wasn't even a trial. There wasn't even a hearing. I mean, there might have been a hearing, but the district court decided, no, it is unconstitutional for this law to happen. And they didn't even have a full trial. They issued a summary judgment. And not only did they issue the summary judgment, they issued what's called an injunction, a permanent injunction from Mississippi enforcing the law against its citizens. So basically, this higher up court said, no, Mississippi, that law, that Gestational Age Act law, is unconstitutional. You cannot enforce that law against anyone, and you lose. Well, as you would imagine, they did not like that. Oh, I got that backwards. The district court decided that that wasn't appealed. That was a case of first instance. Then the state appeals that to the Fifth Circuit Appeals Court, and the Fifth Circuit affirmed the decision of that first court. So the second court now is out here saying, no, it's actually unconstitutional for you to do this law. So we agree with the lower court. You're not allowed to do that. Well, Dodds, aka the state of Mississippi, did not like that answer again. They had lost twice. So they appealed to the United States Supreme Court. And when they appealed to the United States Supreme Court, they said that this act, the state of Mississippi argued, the Mississippi Gestational Age Act is not unconstitutional. And what was their reasoning? Jackson challenged. Okay. The district court granted summary judgment, permanently enjoined enforcement. Okay. So before this court, so this is the Supreme Court talking to us, petitioners defend the act, right? The Gestational Age Act, on the grounds that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational basis review. So this is the argument of the state of Mississippi. They're saying, look, I know these lower courts have both said that this is unconstitutional, but look, Supreme Court, Mississippi is saying it's not unconstitutional. The laws, this is what Mississippi's argument is, the laws that Roe versus Wade and Casey were based on and all that reasoning and everything, they were wrong. They got it wrong. Supreme Court, please reconsider Roe versus Wade and Casey, because we, the state of Mississippi, believe you decided it the wrong way the last time. Okay. So now here we have the holding. The holding is the following, and this is what the Supreme Court decided. This is the heart of their decision. The Constitution, the Constitution does not confer a right to abortion. Roe and Casey are overruled. The authority to regulate abortion is returned to the people and their elected representatives. So I haven't seen anybody else analyze this case like line by line like this, but I thought it was very interesting that the Supreme Court chose the term return to the people, because like I would expect them to say return to the states and the state legislatures, but they specifically said that the right to the authority to regulate abortion is returned to the people and their elected representatives. So the Supreme Court is saying we are going to go back to the time before Roe versus Wade, and we are going to say we are going to allow state legislatures to make laws regulating abortion however they see fit. And then they're going to get into the reasoning why right now. So they say the critical question. So what is the question that is at issue? What is the legal question at issue in this lawsuit? It is whether the Constitution, properly understood, confers a right to obtain an abortion. So that's the question right there. So that's your controlling question if you're doing a case brief. Casey's controlling opinion, the Supreme Court says, skipped over that question. Okay, so what question is it again? The critical question is whether the Constitution confers a right to obtain an abortion specifically, right? And they're saying, well, look, Casey didn't bother answering that question. They just reaffirmed Roe versus Wade, which was that 1972 case. And they reaffirmed Roe versus Wade solely on the basis of stare decisis. So basically, when Casey rolled around, they basically said, look, remember that precedent thing we learned about? Not our issue. We're going to just stand by what was already asked. They didn't meaningfully go back through each and every question on the case of Casey. They just said, look, we already decided this question on stare decisis. But remember, as I told y'all earlier, Casey did kind of disrupt the Roe versus Wade framework, right? They did change some stuff. And I believe at the time they said they changed it based on the current understanding of medical technology and stuff like that. But just so y'all know, so they say Casey's controlling decision didn't even bother answering this critical question. It just did this precedent thing. But then the Supreme Court goes on to say, but applying precedent properly requires that we assess the strength of the grounds on which Roe was decided in the first place. So therefore, since Casey didn't do it, we're having to do it today, is basically what they're saying. And they say, we're therefore going to turn to the first question that the Casey plurality, remember the least common denominator, did not consider. First, the court must review the standard that the court's cases have been used to determine whether the 14th Amendment refers to 14th Amendment's reference to liberty protects a particular right. So what they're going to say is, look, and y'all have probably heard this argument in the discourse, there's no explicit constitutional right to an abortion. Like the Constitution of the United States does not say the word abortion anywhere. But it does say some other stuff that has been used to kind of infer that there may be a right to have an abortion. And one of those, I totally just lost my train of thought. I cannot look at y'all's comments. I get so distracted. So first, okay. Oh, okay. So can we infer? So if there's no writing of an explicit right? If there's no explicit definition of your right in the Constitution, it doesn't end there. Remember, I told y'all laws can be made other ways besides just in the Constitution or Congress. It can be interpreted by the Supreme Court to be a fundamental right. I think marriage is one such right. Like the Supreme Court has decided that's a fundamental right. It's a fundamental right, even though it doesn't say you have a fundamental right to get married, right? And they use all these different frameworks. We can go through all these specifics in the full lecture series, but we're just talking about this case today. So the Supreme Court, authored by Justice Alito in today's decision, goes on to say, the Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. Then they go on to say Roe versus Wade held that the abortion right is part of a right to privacy. We already discussed that, right? That springs forth from these amendments, the 1st, 4th, 5th, 9th, and 14th. Okay. Then in 1992, we had Casey come along, and that court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment, due process clause. Other people have suggested, and this is what I actually believe, and I think that the dissent thinks this too, but again, this is not about my opinion. This is about the Supreme Court's opinion that I'm reading to y'all and explaining to you from their writings, okay? Others have suggested that support can be found in the 14th Amendment's Equal Protection Clause. But the Supreme Court is telling me, no, I'm wrong. They're saying, you're wrong, BJ. Why? Because that theory is wrong, because by the court's precedents, again, stare decisis, which established that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. So y'all remember, we just read those 3 bases of classification. And people have gone to the Supreme Court or people have gone to courts before and argued abortion rights should be granted as an equal protection issue because the right to an abortion only really applies to, and people would say women, or you might say people who can have children. But in any event, the law doesn't seem to apply to everybody equally. And whenever a law doesn't apply to everybody equally, we run into those heightened scrutinies, right? The quasi-suspect class. Because what you're talking about, either women or people who can have children, whatever you want to, however you want to frame it, it doesn't apply to everyone, right? The law only applies to some people. So people have said, wait a second, lawyers and plaintiffs have said, wait, hold on just one second. This only applies to women or, a group of people. So that should be at least a quasi-suspect class, and it should be an intermediate scrutiny. So if it's intermediate scrutiny, the Supreme Court should be asking, is this, what's the standard? Let me make sure I get it right. Was it legitimately related? Is this substantially related to an important government interest? They've gone to court before and they've asked, shouldn't this be like a heightened scrutiny thing because this law doesn't apply to everybody? Well, no. The justices in the Supreme Court in today's Supreme Court decisions are saying, no, heightened scrutiny does not apply to abortion cases. It might apply to marriage cases. I don't know. We can get into that later, but we're not talking about marriage cases. We're talking about abortion cases. And the Supreme Court is saying the Equal Protection Clause does not apply today. And the reason it does not apply, again, I don't agree with this. I'm just telling y'all what they said. And it doesn't matter what we agree or disagree with. What matters is what they said and what they made the law to be. We can do things about it later, but let's not get lost in let's not lose the trees for the forest. It's not a sex-based classification. So for whatever reason, and we can definitely go back and examine those cases, why was abortion not considered to be a sex-based classification whenever only some people can have children, bear children, whatever, only some people. And it's not even like all people who can bear children their whole life, right? It's only a small class of people who truly can bear children at any given time compared to the larger population, right? Because some of them are kids, some of them are old people, whatever, tubes tied, et cetera, et cetera. So it really only applies to like people who would even need one, right? And you do see this rhetoric repeated a lot in social media circles and in even philosophical debates. It's like, if this law doesn't apply to everyone equally, Doesn't it kind of fundamentally make it seem unfair? But there have been arguments on both sides, and I'm not getting into the both sides arguments right now of this particular issue. I'm just telling you what has been actually decided. We can get into that in the lecture series. Okay, so here goes the judge, and they say, rather, regulations and prohibitions of abortion are governed by the same standard of review as what? This is very important. Same standard of review as other health and safety measures. So this is putting a little blinker over my head to say that this might call into question the recent Supreme Court decision on the Affordable Care Act. And I haven't seen anyone else saying that. But I have intentionally, like I told y'all, I've intentionally not looked at a lot of coverage of this case today. I've just been reading it and going through it myself without looking at other people's opinions about it. But this makes me have a little pink flag above my head. Like, are they going to recall, are they going to reconsider their decision from 5-6 years ago where they, made that affordable health care tax or whatever? It's like, if you don't, you have to pay a penalty. If you don't, whatever. Well, I don't know. We'll see what comes up. But this abortion case, they're not grouping in with like the right to marriage and the right to having relations. They're comparing it to other safety measures and the standard, other health and safety measures. So they're not grouping this in as a civil rights case. They're grouping it in as a health and safety case, which I just thought was interesting. It may turn out to be not important at all. I'm just pointing out what I thought, what caught my eye. Okay, so the first question is the standard of review. What's the standard of review? Rational basis. There is no heightened scrutiny. So remember that rational basis thing I told y'all earlier? That's where they tell us that. Next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of ordered liberty. Now, what is ordered liberty? I think they're going to tell us. Hold on one second. Okay. Ordered liberty sets limits and defines the boundary between competing interests. So in this rational basis test, the Supreme Court is going to ask, is this reasonably related to a legit state interest? Like, there's a legit state interest in this. And what Mississippi argued in this case we're talking about today is that their legitimate state interest was in the rights of the unborn human being, right? The Supreme Court has determined that that is a legitimate interest. Now, we can disagree on whether that's a legitimate interest, but it is what the Supreme Court has decided. So the ordered liberty notion, this is what we're looking at here, comes into play where two people's interests collide. So on the one side, you have the interests of the woman, or the person who's bearing the child, the pregnant person, right? We have that person's interest on this side. And this ordered liberty thing is a balancing, right? You can imagine scales. There's some scales back here. Look. Little scales. Just imagine the scales. One person's interests are over here. That's your rights, right? To privacy is what it's been based on. I think it should have been based on a right to bodily autonomy, but nobody asked me and I wasn't alive then. So that's what we got, privacy, right? So your right to privacy on this side, if you're, wanting to have a procedure, abortion procedure. And then on the other side, you're going to balance the state's interest. Now, in this case, the state has said their interest. Over here, this interest is your right to privacy. Over here, this interest is the state's interest in the life of the unborn human being. Again, I'm not sure I agree with that interest. Like, what interest would they have in the right of an unborn human being? But the Supreme Court disagrees with me. And they say the state does have a legitimate interest in the right of in the life of the unborn child. So the Supreme Court is balancing these two interests. And the way they balance those interests is through this notion called ordered liberty. Okay. So again, the definition of ordered liberty is sets limits and defines the boundaries where two interests conflict. So when the pregnant person's interests conflict with the government's interest, the ordered liberty is the lens they're going to apply and determine what's the limits, what's the boundaries through using, like, for example, this rational basis test that is going to be applied in this case. Here, the court finds that the right to abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, and that was that the 14th Amendment Due Process Clause provides substantive and procedural protection for liberty, has long been controversial. The court is saying like we've been arguing about this since it came out, is what the court is saying. The court's decisions have held that the Due Process Clause protects two categories of substantive rights. Okay, so the Due Process Clause of the 14th Amendment is where this privacy or this liberty argument comes in from Casey, which is the only thing that was left alive in Casey. It was just this liberty argument. So it was like a Jenga house, and it was just like one little block to pull and the whole thing's coming down. That's what happened. So it's long been controversial about this liberty thing anyway, is what the court is saying. The court's decisions have held that the Due Process Clause protects two categories of substantive rights. Now, those categories are the ones that are guaranteed by the first 8 amendments of the United States Constitution. That's the Bill of Rights, right? Amendment 1 through 8, which is, I think, it's the First Amendment, the freedom of the free speech, freedom of religion, all the way through like the 8th Amendment, I think, is cruel and unusual punishment. So all first of those 8 ones, the Due Process Clause does protect. But in none of those, they're going to tell you, in none of those 8 amendments are you going to see the word abortion, right? So they have to apply something different to it. And the other sets of rights that are guaranteed by the Due Process Clause, protected by the substantive rights in the Due Process Clause, or considered to be substantive rights, are those deemed fundamental, that are not actually mentioned in the Constitution, but that the Supreme Court has still decided were fundamental. Again, marriage is one such right. But I think education is a fundamental right, I think, like to pursue education. I don't know. Actually, don't quote me. It might not be. It's not a fundamental right. I'm wrong. I think it should be. This is another one where I disagree with the Supreme Court, but I got enough sense to tell y'all what they actually said. Like, that's the thing. Like, what I keep seeing online is like, you can talk about your feelings and you can talk about the law. You can do it separately. You don't have to like act like your opinions are the law. You know what I mean? Like, I wish my opinions were the law. Wouldn't that be nice? But, you know, the law don't agree with me on everything. So what we're talking about here is the courts have held that due process protects two categories of substantive rights. The first category is amendments 1 through 8. The second category is those that are fundamental rights, but they're not actually maybe explicitly mentioned in the Constitution, but we still agree they're fundamental rights. In deciding whether a right falls into either of these categories, the question is whether the right is deeply rooted in our nation's history and tradition. Okay, this is the question they ask in determining, is this protected by due process? Is this really protected by due process? Because that's the only thing that Casey is hanging on to. So if we can attack that, abortion is overturned, or whatever, rights to it are overturned. Okay. So they're going to ask, is this right deeply rooted in our history and tradition? Whether it is essential to this nation's scheme for ordered liberties. Some such rights are the right to travel, the right to vote is a fundamental right, right? Like you have the fundamental constitutional right to vote. And so that right it fits this definition, right? Deeply rooted in our nation's history and tradition. It's deeply rooted in our nation's history and tradition to be able to have the right to vote. And it also asks whether it is essential to this nation's scheme of ordered liberty. And then they say, but the term liberty alone doesn't really give us a lot to go on. So we had to go to the next question, which is historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause, which again is what the Casey decision is based on, the liberty clause, the liberty interest protected by the Due Process Clause in the 14th Amendment. So when we're talking about this liberty interest, which is the only thing that your abortion rights are hanging on to right now, and if we can get rid of that, then that's the last pin and y'all are done. when we're asking about this liberty thing, it is very important to look at the history of that right in this country, is what the Supreme Court is saying. So, in interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own views about the liberty that Americans should enjoy. So basically, what they're saying here is don't shoot the messenger. We're not making a decision based on our feelings or what we think you should be able to do. We're making this decision based on what the 14th Amendment actually protects. Now, again, I just want to reiterate, I'm not saying I personally agree with everything this court is saying right now. I'm just telling y'all what they said. So don't shoot the messenger times two. They said, in interpreting this liberty, we can't just willy-nilly apply stuff that we think is supposed to be a liberty. We have to actually look at the historical context of what's been recognized in this country as a fundamental right. Like, that's so obvious that it's supposed, like, we all agree this is supposed to be a fundamental right, even though it's not listed. Like, it's just so obvious, like the right to vote or the right to get married, right? So the court has been reluctant to recognize rights that are not mentioned in the Constitution. Then they go on to say, guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds, and this is a finding, the 14th Amendment clearly, they say, clearly does not protect the right to an abortion. They go on to say, actually, until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had ever recognized such a right until the latter part of the 20th century, they're saying. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. So what they're doing is looking into the history of abortion rights in the country to determine whether it's like a deep tradition in the nation to allow abortion. Not only allow, but protect the right to it, right? And then they go on to say, indeed, abortion had long actually been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s that expanded criminal liability for abortion. So in the 1800s, they started cracking down on abortions. And a big reason for that was the invention of the American Medical Association. The American Medical Association had an interest, that's the licensing body for doctors. Now, they had an interest in making sure that doctors were the people who fully would be able to enact medical procedures and oversee pregnancy and the stages of pregnancy. So in 1850 or so, the American Medical Association is invented, and very quickly they start lobbying to make abortion a crime. And the reason they wanted to make abortion a crime back in 1850 or so was because there was all kinds of other people who would help people have babies, like midwives and doulas and homeopaths and things like that. And so the American Medical Association is basically a cartel that wanted no competition in the childbirth industry. And so they started lobbying to make all these very restrictive laws on abortion. And states started actually outlawing it because, like, oh, the doctors are telling us to, we must listen to them. But it really was guided from a very grotesque financial incentive that actually limited women's rights to be able to choose how we bring babies into this world. And it kind of made it, a lot of people be pigeonholed into this doctor route. And, you know, it changed the face of everything over the last, 150 whatever years. Okay. By the time the 14th Amendment was adopted, 3/4 of the states had actually made abortion a crime at any stage of pregnancy. But again, this wasn't that long ago. It was in 1850 and was like, well, let's see. Yeah, I guess that was like 100 years. So there's like 100 years by the time these laws started protecting women's rights to privacy and contraception and stuff. that the American Medical Association had gotten a lot of states to pass these laws. This consensus endured until the day that Roe was decided. Roe either ignored or misstated the history, and Casey didn't even consider the faulty historical analysis. But that's not the only thing that the Supreme Court needs to consider. It's just one of the things. And they said, so this one thing, no, there's no national history of abortion or whatever. That's what this court is trying to argue. Now, another argument could be made. What about the last 50 years? Like, don't you think that's a national history? Like, the people alive today would remember that a lot more than some crap that happened in 1850. And if you made that argument, I would agree with it, but the Supreme Court doesn't seem to give it much stock. Respondents' argument that this history does not matter. Okay, so that's the plaintiff. That's the Jackson Medical Center or whatever. Their argument that history does not matter flies in the face of the standard the court has applied in determining whether to assert a right that is not mentioned in the Constitution. The Solicitor General, so one of the people arguing this case, the losers of this case, right? They claim that it is doubtful that abortion was ever firmly established as a common law crime. So basically, this guy's like, we don't even know if it was established as a common law crime. And the Supreme Court is like, that's not true. It definitely was a crime. They suggest the history supports abortion right because of the common law's failure to criminalize abortion before. Okay, whatever. That's more of the same. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right, like a liberty right. Roe termed this as a right to privacy, which, remember, I told you I was decided on privacy grounds. If I was arguing this case, I wouldn't have argued it on privacy grounds, but I wasn't around at that time and nobody asked me. Okay. And Casey, right, Roe was decided on privacy, and Casey was described as a freedom to make intimate and personal choices that are central to personal dignity and autonomy. Ordered liberty sets the limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of the woman who wants the abortion and the interests of what they termed the potential life. But the people of the various states may evaluate those interests differently. This is what the Supreme Court is starting to say. The people in each state might have a different opinion on abortion than the 1973 and the 1992 Supreme Court. The nation's historical understanding of ordered liberty doesn't prevent the people's elected representatives from deciding how abortion should be regulated. So this is their conclusion. We have to allow the states and the legislators to decide in their states how to regulate abortion because of this notion of like abortion isn't like an entrenched right. Again, there's a very good counter argument, which is, the right has been around for 50 years at this point. And the people who are alive today would have always known this right or known it since, it was the last 50 years. But that is not what the Supreme Court is agreeing with. They're saying no. There is no traditional national history of allowing a right to this. And so for that reason, we can't outlaw states being able to ban abortions. We have to let them do it if they want. That's the Supreme Court's argument. Again, don't shoot the messenger. I'm just telling y'all what they said. Finally, the court considers whether a right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. The court concludes the right to obtain an abortion cannot be justified as a component of a larger, broader, entrenched right to liberty. Any attempt to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. So this I put an underline in red because I just disagree. And I feel like this is somewhere I do want to put my opinion. Because the Supreme Court is basically saying here, you don't have any damn right to autonomy, some broad notion of autonomy to your body. No, you don't have a right to define your own concept of existence. Absolutely not. That's not a constitutional right. That's what the Supreme Court's saying here. And I'm going to say, I disagree. I believe we do have a fundamental right to bodily autonomy. I believe we do have a fundamental right to decide and determine and define our own concept of existence as far as what's going on in our bodies and stuff like that. The Supreme Court does not agree with me. They said wrong, incorrect, BJ. You don't have that right. You're wrong. Those criteria at a high level of generality could license fundamental right. And this is another thing I don't agree with. This is why I don't agree with it. Because the Supreme Court is saying, look, listen, if you had some fundamental right to bodily autonomy and to, define your own concept of existence or whatever, then you would be able to go out and do drugs. And look, this is their word, not mine. Or commit this type of work and the like. But hold on, y'all. It is 2022. Don't you think that we do have the right as human beings to decide whether or not we want to alter our state of consciousness by taking an illicit drug? This is a philosophical question. You don't have to agree with me. But at some fundamental level, who really is the government to tell me that I can't eat a mushroom that grew out the ground or smoke a plant that grew out the ground? But this is what their precedent is based on. And they're telling you what they think right here. Any attempt to justify abortion through appeals to some broad right of autonomy is wrong. If that was the case, you would be able to do drugs and sell your body for, transactions. But no, you're not allowed to do that because there's no broader right to autonomy. But I just disagree. And this is one of those parts in the opinion that I feel like I need to interject my opinion. I believe we have a right to decide to alter our states of consciousness. I believe we have a fundamental right to try out whatever we want to try out and define our own existence. But y'all don't have to agree with me. This is like a philosophical question. There's no right or wrong. It's just my belief. The court goes on to say what sharply distinguishes the abortion right from the rights recognized in those cases that Roe and Casey rely on is something that both decisions acknowledge. So what distinguishes abortion rights from other rights? This is what they're saying. It's different because it destroys what Roe termed a potential life and what the law challenged in this case calls an unborn human being. So we're talking about these other rights about potential lives and unborn human beings. None of the decisions that Roe versus Wade and Casey rely on involve that critical moral question. So the Supreme Court is now asking a moral question. They're saying, who are we to determine when a life starts and when a human being is a baby versus a fetus versus an unborn human being versus a potential life? The Supreme Court is saying rightfully that they don't really know. They're not doctors. They're not ethicists. They're not philosophers. They are just there to interpret the law. And the law doesn't actually say anywhere in an agreed upon way when a life begins. So that part is true. They're saying abortion is different because the one thing is this moral question. And the moral question is, when does a life begin? And I know for 100% fact, everybody in this chat, everybody in the comment section is going to have a different opinion on this. But the truth is, none of us can convince everybody else of our opinion. So we have to find some common ground. We have to find some common denominator. And what is the common denominator? No one's definition of when a life starts or ends is more right than the next person because we haven't been able to prove when a life starts. There's all these questions about souls and spirits and being able to live outside the womb on your own and concepts and notions of like having to use your body to support a life. Is it alive? Like there's all these notions, and we can definitely get into a philosophical discussion, but the common denominator is you're not going to probably convince somebody of your definition of when a life starts. And the Supreme Court is saying, so who are we to decide when a life starts? And if that's a moral question that we have to address, that makes the case that we're considering right now a little different than like a marriage case, right? Because there's no potential life or unborn human being. Even if they don't decide when a life starts, that's a moral question that the other cases that Roe depends on don't really have to answer. So that's what the Supreme Court's saying here. Accordingly, those cases do not support the right to obtain an abortion. So the critical difference here is that there's this uncertainty, a moral question about when a life begins. And the Supreme Court is saying Because of that moral question, who are we to impose on a state or the people, the voters of a state, when the life begins and when the interest of the person begins and all that? Like, that should be left up to the people inside the states to decide. That's what the Supreme Court is saying. And I know that's what a lot of people are upset about, but that is what they are saying. And that is what we are here to do in this video, to tell you what they're saying. Okay. So then they're going on to the next thing. The doctrine of stare decisis does not counsel continued acceptance of Roe and Casey. Stare decisis plays an important role in protecting the interests of those who have taken action in reliance on a past decision. It reduces incentives for challenging the precedents that have already been set, like Roe versus Wade. It contributes to the actual and perceived integrity of the judicial process, right? Like, once something gets decided, we need to know that the judge has decided it right. So why don't we just keep the decision once it's been made? Also, the precedent thing restrains judicial hubris by respecting the judgment of those who grappled with really important questions in the past. And then they say, but there's limits. And the stare decisis precedent thing that we do is at its absolute weakest when we are considering constitutional rights. So they go on to say some of the court's most important constitutional decisions have overruled prior precedents. That would be Brown versus the Board of Education, which overruled Plessy versus Ferguson. Plessy versus Ferguson basically allowed racial discrimination in public schools, and Brown versus Board of Education was a Supreme Court case that overruled Plessy versus Ferguson and said, no, you cannot discriminate based on race in school. And that would have been a strict scrutiny basis standard of review because it discriminated based on race, like we mentioned earlier. The court's cases have identified factors that should be considered in deciding when a precedent should be overruled. So now we're going to look at the factors that the court considered in overruling Roe versus Wade. Number one, the nature of the court's error. Like the decision in Plessy versus Ferguson, and this is an indictment right here. Roe was egregiously wrong and on a collision course with the Constitution from the day it was decided. That's what the Supreme Court is saying. Casey perpetuated Roe versus Wade's errors, calling both sides of the national controversy to resolve their debate. But in doing so, Casey declared a winning side. Those on the losing side in Casey, who are the ones who sought to advance the state's interest in the fetal life, they could no longer seek to persuade their elected representatives to adopt policies consistent with their views. So you can no longer go to your local lawmakers and say, hey, let me make a law restricting abortion or banning abortion. And the Supreme Court saying, well, once Roe was decided and Casey came along, then people couldn't actually seek to persuade their representatives to make policies consistent with their moral views. The court short-circuited the democratic process by closing it to the large number of Americans who disagreed with Roe, which I have a lot of feelings on this sentence, but that's something I don't have time to get into right now. That's just what they said. Okay. The next factor they're going to consider in determining whether to overturn Roe versus Wade or any precedential decision is the quality of the original reasoning. So without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy divided into trimesters, much like those that one might expect to find in a statute or regulation. So the Supreme Court is saying, we kind of took a little bit more over the job of like the legislators, and that's really supposed to be a separate branch of government. Roe's failure to even note the overwhelming consensus of state laws in effect in 1868 is striking. And what it said about the common law was simply wrong. Then, after surveying history, the opinion spent a lot of paragraphs conducting the sort of fact-finding that you would actually expect to be undertaken by a legislative committee. So the court was acting like a legislative committee. And the court in Roe versus Wade did not explain why the sources on which it relied shed light on the meaning of the Constitution. Wait, did not explain why the sources on which it relied shed light on the meaning of the Constitution. I don't know what that means. As to precedent, so look, they're going intern like about the reasoning, right? They relied on precedent, but they cited in Roe versus Wade a excuse me, a broad array of cases, and the court found support for a constitutional right of personal privacy. But Roe conflated the right to shield information from disclosure and the right to make and implement important personal decisions without governmental interference. So again, this is where they should have asked me, but I wasn't around and nobody asked me. Roe was based on a privacy right. And the Supreme Court is saying, but the right to privacy has more to do with like keeping your information secret. It doesn't have to do with the important personal decisions that you need to make, which is more of a health and safety related decision. It's not just you're not keeping records from someone. Abortion is not the same thing as keeping a record from someone, is what the court is saying here. None of these decisions involved what is distinctive about abortion, which is that moral question of when a potential life starts. So when the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were consistent with the relative weights of the respective interests involved and the demands of the profound problems of the present day. And then the Supreme Court today goes, but wait, these are exactly the sort of considerations that legislatures are supposed to consider when they draw lines that accommodate competing interests. The scheme that Roe produced looked more like legislation, and the court is not a legislative body. An even more glaring deficiency in the reasoning of Roe was that it failed to justify the critical distinction between viability, right? Like, why did they justify the fetus ability to live inside the womb and outside the womb? They didn't really give enough reasoning on that point. So for that reason, we can't withhold their reasoning isn't strong. Even philosophers and ethicists have looked into this and they can't find support for that Roe versus Wade thing. Okay. The most obvious problem with any such argument is that the viability has changed over time. And the court says this decision is heavily dependent on other factors like medical advances, where we are in the medical world, the availability of quality medical care, and they have nothing to do with the characteristics of a fetus, like of being in the first or second trimester. But the question that I ask when I read this part is, doesn't this presuppose that people have access to availability of quality medical care? I mean, I would say that there's not really very meaningful access to quality medical care today more than there was back in the day. Like, sure, maybe like for rich people, but like people still can't afford quality medical care. So it seems to me like the court is basing this decision on being able to access available medical care. And I just kind of like call bullshit a little bit. Like, that's not really the case for a lot of people. So like, let's not like lie in the Supreme Court decision. But anyway, when Casey revisited Roe almost 20 years later, it reaffirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. So Casey didn't really get into all of Roe's reasoning. And the Supreme Court today is saying, well, that was for a good reason because the reasoning's bad. The court in Casey abandoned any reliance on a privacy right. Okay, the privacy thing went out the window. And instead, they grounded the abortion right entirely on the 14th Amendment due process clause. And as we've already discussed earlier, in order to have a right be protected by the 14th Amendment due process clause, if it's not explicitly listed in the Constitution, there has to be like a national history of protecting that right. And the court is saying there is no such history of protecting that right. So for that reason, it's not going to be able to fall under this due process clause. The controlling opinion in Casey criticized and rejected that trimester, right? In the first 2 trimesters, then it flips over to the 3rd trimester. It rejected that framework. It threw it out the window and it went bye-bye. It replaced it with this test called the undue burden test. We don't have to get into that test. Just keep that in your mind. That's what it replaced. The undue burden test replaced the trimester test. Casey, in short, refused to reaffirm or completely rejected the reasoning from Roe versus Wade. Very important aspects. There were glaring deficiencies that weren't fixed, And it endorsed what it termed as Roe's central holding, while suggesting that a majority might not have thought it was correct. They didn't provide any new support for the right to an abortion. And there was no firm grounding in constitutional text, history, or precedent. So the next factor that we're going to talk about, right, so the first factor, just to remind y'all, was the nature of the court's error. The second factor was the quality of the court's reasoning. The factor of what? In determining whether or not to overturn a precedent. What are the factors that are considered? Number one, the nature of the court's error. Number two, the quality of the reasoning in that original court case, which would have been Roe and Casey. They were both overturned. The third factor is what they're calling workability. Deciding whether a precedent should be overruled depends in part on whether the rule it imposes is workable. What does workable mean? Whether it can be understood and applied in a consistent and predictable manner. Long story short, the court said it's not workable. Continuing to stick to that undue burden test would undermine and not advance the even-handed and predictable, consistent development of legal principles. So basically, it's not workable. The Supreme Court decided. So what was the first thing they decided? They decided on the first factor, the nature of the court's error. It was a very big error. So they said big error. Number two, the quality of the reasoning in Roe versus Wade on that original case. Bad reasoning. Okay. That's what they said, not me. Okay. Number three, is it workable? Workability? No, not workable. Okay. Number four, effect on other areas of law. Roe and Casey have led to the distortion of many important but unrelated legal doctrines, and that effect provides further support for overruling those decisions. So so it's having effects on other areas of law like marriage and intimate relations, right? It's affecting areas of law that weren't meant to be affected. And so it is having a big effect on law, is what the Supreme Court is saying. Again, I'm not saying I agree with them. I'm just saying this is what they're saying. And then the fifth factor that the Supreme Court is going to address in determining whether to overturn a constitutional precedent like Roe versus Wade or Casey, overruling is called reliance interests. And this is their conclusion. Overruling Roe and Casey will not upend concrete reliance interests like those that develop in cases involving property and contract rights. In Casey, the controlling opinion said that traditional reliance interests are not impacted because getting an abortion is generally, quote, unplanned activity, which I find interesting, like to say. And reproductive planning could take virtually immediate account of any sudden restoration. So this is like a very fancy way of saying, like, okay, if the right to abortion is gone away and eliminated, all you have to do is start planning. All you have to do is start planning your reproduction better, and you can just simply avoid having an abortion. And I'm going to say this is another spot that I just disagree with. Like, I think there's like very valid reasons why, like, oh, look, reproductive planning can make up for like, you can take contraception. Not only just in a common sense way is that incorrect, like, just doesn't sit correctly with me. Like, there's many common sense reasons why somebody might not be able to just simply plan better, right? There's accidents, for example. There's mistakes, for example. There's instances where the person didn't consensually engage in the interaction, if you get my drift. So there are reasons other than just plan good, right? So just from a common sense perspective, I have to disagree. Also, from a legal perspective, I have to disagree, because right here, the Supreme Court is resting its reasoning on, oh, girl, just plan your pregnancy better. But that's not a viable thing, because we just discussed that the right to contraception, which is planning, is also up on the table now as a privacy right. So, like, if they're going to overturn this, are they going to overturn the contraceptive right? Because if they are, then they don't need to take for granted that people are going to be able to do this planning. Do y'all see what I'm saying? It's kind of like a circular argument. Like, if the contraceptive, which is pregnancy planning, is based on a privacy right, and y'all are saying there's no privacy right to abortion, are you about to also say there's no privacy right to contraception? And if you do say that, then this reasoning that you're providing right here is incorrect, which is girl, just plan better. Because you can't plan better if it's illegal to get the contraception. And they're kind of putting that up on the table at this point. Like, who knows what's going to be decided. So then they go, instead, the opinion perceived a more intangible form of reliance, namely that all people had organized intimate relationships and made choices that define their views of themselves and their places in society, and reliance on the availability of abortion in the event that the contraception should fail. Okay. So basically the argument was, look, people are relying on being able to get an abortion because it's a right. It's a constitutional right we've established. And the court and also the people in the Dodds in Mississippi are arguing, no. As soon as people find out that there's no right to abortion, they can start planning better, and then that will be a remedy. There's no reliance on abortion. Again, that is a fundamental Achilles tendon, is what I just told y'all about, is like, if they're going to take away the right to contraceptives, then you can't just plan better. Like, you got to leave somebody some type of choice here, right? Okay. And the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The contending sides in this case make impassioned and conflicting arguments about the effects of the abortion right on the lives of women, as well as the status of the fetus. In Casey, the plurality's speculative attempt to weigh the relative importance of the interests of the fetus and the mother represent a departure from the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. Oh, sorry. So again, we're right here. This is what I just read. Courts do not substitute their social and economic beliefs for the judgment of legislative bodies. So courts are not legislators and they're not lawmakers, and we can't be making laws. And the court just said, Roe versus Wade and Casey looked a lot more like a law than a court decision. That's what they're saying. That's not what I'm saying. That's what they're saying. The Solicitor General, who's the plaintiff in this case, suggests that overruling Roe and Casey would threaten the protection of other rights. This is a big, important part right here. They're arguing, and I've seen this argument made a little bit online. They're arguing that, look, if you overrule Roe and Casey, that is going to threaten the protection of other rights under the Due Process Clause. And the court is saying this in pink. The court emphasizes this decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. So you do have Clarence Thomas later on in his concurring opinion saying we should revisit same-sex marriage. We should revisit, Lawrence. We should revisit all this other stuff. But the majority, the least common denominator of the Supreme Court, the majority opinion, which is now law, says the following: nothing in this opinion should be understood to apply to any other type of case, period, whatsoever, other than abortion rights. Okay. Casey identified another concern, namely the danger that the public will perceive a decision overruling this decision as influenced by political considerations. So in Casey, in the court decision in Casey, it was argued that overturning a big, huge case in the Supreme Court would be perceived as like being done for political reasons, right? In Casey. But the Supreme Court says the court cannot allow its decisions to be affected by whether or not people think we're making a political decision. A precedent of this court has to go under the principles of precedent, right? Stare decisis, under which adherence to precedent is the norm, but there are exceptions to that. If the rule was not the case, if that wasn't the case, if we couldn't overturn laws, then we would still have racial discrimination in public schools, which everyone probably would agree was very good to overturn. It was very good to overturn that. There shouldn't be no racial discrimination in a public school. They just shouldn't. But they're saying here, we can't base our decisions on politics. We can't base our decisions off what the public is screaming and hollering about. We have to look at the law, and look what they say down here. The court's job is to interpret the law, apply long-standing principles of stare decisis, and then decide the case accordingly. And then now they're moving to the next point. We're almost done. I think what this is the last page or second to last page. Under the court's precedents, rational basis review is the appropriate standard to apply when the state abortion regulations undergo a constitutional challenge. That's this rational basis test we learned about at the beginning of the lecture. Given that procuring an abortion is not a fundamental right, constitutional right, according to the Supreme Court, it follows that the states may regulate abortion for legitimate reasons. And when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. Now, a lot of y'all I know are going to say, but that's exactly what happened in this case. And I don't know that I can disagree with you. Maybe these people did make a decision based on their political beliefs. But what we are looking at right now is the written reasoning that they gave. And that is all we can go on. We can get all in the weeds about their political beliefs, believe this, and that's what they decided it on. And you could be right, but that's not the purpose of today's discussion. And that's not what we're talking about. The courts are saying on paper, some statement that I absolutely agree with, citing Ferguson, Plessy v. Ferguson. Courts cannot substitute their social and economic beliefs for the judgment of lawmakers. And I do agree with that. Now, did they do that in this case? Y'all can argue about it in the comments. That applies even when the laws at issue concern matters of great social significance, such as this one, and of moral substance. A law regulating abortion, like other, again, they're grouping it in with health and welfare laws. So just like other health and welfare laws, a law regulating abortion is entitled to a strong presumption of validity. It must be sustained. The law must be upheld by the Supreme Court if there is a rational basis on which the legislator could have thought that it would serve a legitimate state interest. Mississippi's Gestational Age Act is supported by the Mississippi legislature's specific findings of fact, which include the state's asserted interest in protecting the life of the unborn. These legitimate interests provide a rational basis. This is the rational basis lens. Remember the glasses they had to put on for the Gestational Age Act. And it follows that respondents' constitutional challenge must fail. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority, took that authority away from the people in the individual states. That's what the Supreme Court's saying, not me. The court overrules those decisions and returns the authority to the people. Again, the people, not the states. They're specifically saying we are returning the authority to the people and their elected representatives. Now, here's the people who, the judges who agreed, disagreed, and all that. So we have Alito delivered the opinion. Thomas, Gorsuch, Kavanaugh, and Barrett joined. Thomas and Kavanaugh filed concurring opinions. Roberts filed an opinion concurring in the judgment. And then we had Breyer, Sotomayor, and Kagan filing dissenting opinions. So there's a couple things that I am so tired. I cannot go on for much longer, but there's a couple things I want to leave y'all with here. The court did not return these decisions to the states. They returned them to the people. And for those of you who are feeling a little downtrodden today, who are feeling a little powerless and all of that, I just want to leave you with this. The court returned the decision to the people. And we, the people of the United States of America, get to decide what we want our laws to be. We are not powerless. We are not powerless to the whims of the Supreme Court. Although, if you read the mainstream tabloid media, that is what you will believe. We are not. There are ways for we, the people, to express our opinions. And I ain't about to say, oh, go to the voting polls. No, there's other types of things you can do. We can discuss what those are in a later date because I'm getting a little scatterbrained at this point, just been on doing this all day. But we, the people, are the ones who get to decide what our laws are. And if we, the people, all collectively agree that there's a fundamental right to make medical decisions for ourselves, like maybe getting a vaccination, maybe not deciding not to get one, government mandates on other healthcare decisions, like perhaps wearing a mask somewhere, right? All of these rights can be implicated. And at the end of the day, what the Supreme Court is analyzing is a law that was made by the state of Mississippi. The Supreme Court didn't come out and say abortion is illegal. No. They said we're returning the decision to the people and their elected representatives. So if your elected representative isn't on your same wavelength as far as the rights that you believe are fundamental, then you can vote. You can not only vote, you can campaign, you can run for office. Nothing is stopping you except maybe an age limit or something like that. There's ways that we, the people, can take this power and make these things our decisions. Now, I do believe in a fundamental right to medical autonomy, period, including vaccinations, including abortion, both of them. And that's why you won't see me on either side of the political spectrum. I'm above it looking down because I don't believe that the government should be able to tell me what I can put in my body or what I have to keep in my body. But that's not the current state of the law. But fret not. We can make it because the Supreme Court explicitly returned the right to decide these issues to the people. They returned the right to decide these issues to us. We are the deciders. We are not helpless and at the whims of the Supreme Court. No. We get to decide in our local communities, in our respective states, what is going to happen. And also, we get to vote for the federal legislatures. They could write a law tomorrow and pass it that does protect certain fundamental rights. There's constitutional amendments. There's other ways to do things. And I don't mean to be like glib about it. Like I do understand that there are other concerns and issues here. But this isn't just like, oh, the big mighty Supreme Court gets to decide about my life. Yeah, they do. That is true. They do. But it's about time that we wake up and start getting a little bit outraged about all of the different ways that the government does control our bodies, make us take certain medications, vaccines, whatever else you want to talk about. Y'all know this video is going to be demonetized immediately. So share it if you can, because there is absolutely no way that this video is going to remain monetized. It might even get removed from the channel. So I'll maybe post it elsewhere. But thank y'all so much for hanging out. I worked really, really hard on this case. I was very nervous to do this live. I know there's a lot of very strong opinions, and I want to be respectful of all those opinions. This is kind of what I want to do over here on this channel, because I do think that even on these issues, these hot button issues where we disagree, we can all agree to some fundamental values amongst each other of respect and civility. And if y'all can't agree to those fundamental values of respect and civility, then go to one of the places on the internet where they're going to let you act a fool, because it's not going to be this comment section. Anyway, that's all I'm going to be having for today. Thank y'all for hanging out. Thank y'all so much for the super chats. I do apologize that I wasn't unable to individually read the super chats this time. I had to stay out of the chat because it was very distracting, but I do appreciate y'all keeping it respectful. Definitely huge shout out to the moderator team. I know I haven't looked at the comments, but I know y'all were on fire, on top of things. Facts and defamation. Talk to y'all later. Love you, Mina. Bye.